for the first response. Thank you, President. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Guyana. Judgment delivery in CCJ application GYCV number 2 of 2020 between Mohamed Irfaan Ali, Bharat Jagdeo, and Eslyn David, Chief Elections Officer, Chairman of the Guyana Elections Commission, the Guyana Elections Commission, the Attorney General of Guyana, Mark France, Daniel Josh Kanhai, Lennox Schumann, Shazam Ali, Abedin Kindi Ali, and United Republican Party, Joseph Harmon. Today's panel comprised their honors, Mr. Justice Saunders, President and Presiding Judge, Mr. Justice Witt, Madam Justice Rajnath Lee, Mr. Justice Barrow, and Mr. Justice Jamadar. May we have the appearances, please? Thank you.
May it please Your Honors, Devendra Kisoon, in association with Mahabir Anil Nandalal, Sanjeev Datadin, Marcy Nadir Sharma, Theresa Haddad, Rishi Das, Clay Hackett, all led by Douglas Mendez, Senior Counsel, on behalf of the intended applicants appellants, Dr. Irfaan Ali and Dr. Bharat Jagdeo.
May it please the Court, Your Honors, I, Rhonda Keller, appear with Mr. Timothy Afonso, Mr. Keith Scotland, and we are led by Mr. Roysdale Ford, Senior Counsel, and Mr. John Jeremy, Senior Counsel, and instructed by Mr. Mara Robertson. We appear for the first named intended respondent, Eslyn David.
May it please Your Honors, Kim Kite Thomas, I appear, Your Honors, on behalf of the third named respondent, Chairman of the Guyana Elections Commission.
May it please Your Honors, the Attorney General appears in person, together with Mr. Justice Simon QC.
Does anyone appear for Mark France?
If it please Your Honors, Timothy Jonas for the 6th, 7th, and 8th named respondents, led by Mr. Ralph Ramkaran, Senior Counsel.
And the appearances for Shazam Ali and Abedin Ali. I see Mr. Yes. Mr. Khan, are you hearing us?
Together with Kashir Khan and Kalesh Loknath for the 9th and 10th respondent.
Yes, thank you. Mr. Amor, you're for Joseph Hammond?
That's correct. May it please Your Honors, I appear for Mr. Joseph Hammond, and with me is Mr. Raphael Ajodio.
And is Mr. Hossein, who's for the United Republican Party?
If it pleases Your Honors, Mr. Fayed Hussain, Senior Counsel, leads me, Devish Baraj, Ms. Sasha Brijmohan Singh, Mr. Adam Hussain, and we are instructed by Ms. Candice Bharat Nahus.
Okay, thank you, Counsel, and good afternoon to you all. I propose to read a summary of the court's judgment. This summary is, of course, not intended to be a substitute for the reasons of the court or to be used in any later consideration of the court's reasons. The actual judgment of the court will be delivered to Council shortly after these proceedings. Periodic elections that are free and fair are the lifeblood of any true democracy. It is a matter of considerable concern to the people of Guyana that although general and regional elections were held as long ago as 2nd of March 2020, to date, the results of those elections have not been declared, and the President and members of the National Assembly have not been appointed. This court is acutely conscious of the great importance of these proceedings and our ultimate responsibility to safeguard and uphold the provisions of the Constitution and the high constitutional values contained in the preamble to that sacred instrument. The Constitution expressly declares that it is the supreme law, and all arms of state, whether legislative, judicial, or executive, are subject to it. It is against this background that this court is called upon to determine the central questions that have been placed before us. Whether A, this court has jurisdiction to hear and determine this matter, and if it does, whether B, the Court of Appeal rightly assumed and or acted within the jurisdiction conferred on it by Article 177(4) of the Constitution. A brief background is in order. After the elections that were held on the 2nd of March, the Guyana Elections Commission, or GCOM, decided to recount the votes cast in all 10 administrative regions. To facilitate the recount, GCOM issued Order Number 60 of 2020. This order was gazetted and dated 4th May 2020 and later amended by Order Number 69 of 2020 that was dated 29th May 2020. Throughout the judgment, we refer to the order as amended simply as Order 60. Order 60 was aimed at a transparent recount process. For example, at each workstation where recounting was to be carried out, there was to be installed a picture of the ballot box depicting the state in which it was delivered to the workstation. An audio feed of the recount process was installed at each station. An audiovisual facility was established in the tabulation center, broadcasting live the entire tabulation process. Order 60 carefully set out how the recount process should unfold. Paragraph 12 of the order required the Chief Elections Officer, or the CEO, to do certain things. He was to tabulate the matrices containing the statements of recount of the 10 electoral districts and to submit these to the Commission in a report, together with a summary of observation reports for each district. During the recount process, Mr. Joseph Hammond, an election agent of the APNU-AFC Alliance, wrote several letters to GCOM alleging anomalies, irregularities, voter impersonation, and fraud. On the 13th June, the CEO submitted his report. He indicated the votes that were cast and counted for each list of candidates, but he also drew attention to what he considered to be widespread irregularities. It was his assessment that it could not be ascertained that the results for the districts met the standard of fair and credible elections. On receiving this report, the GCOM chairperson announced publicly that some of the allegations set out in the CEO's report were serious, but the Commission did not have the machinery to adjudicate them. The chairperson pointed out that the Constitution had vested in the High Court an exclusive jurisdiction to determine the legality of an election, and the Commission could not arrogate unto itself the power to annul elections. By letter of the 16th of June, the chairperson accordingly directed the CEO to prepare and submit his report by 1 p.m. on 18th June 2020, using the results derived from the recount. Before the CEO could comply with this request, Ms. Eslyn David launched these proceedings by an application made to the Court of Appeal. Ms. David's application sought to invoke the Court of Appeal's jurisdiction under Article 177(4) of the Constitution. Decisions of the Court of Appeal under that article are final and cannot be appealed to the CCJ. Ms. David's application challenged the credibility of the recount by GCOM. She requested an interpretation of the phrase, quote, "more votes are cast," unquote, in Article 177(2)(b) of the Constitution. Her application was premised on the notion that Order 60 created a new and completely different legal regime, and that GCOM had abdicated its responsibility to determine the election's credibility under that order. The Court of Appeal heard Ms. David's application on the 20th June 2020 and, commendably, on 22nd June 2020, delivered its judgment. A critical issue was whether the Court of Appeal possessed the jurisdiction to hear Ms. David's application. That is to say, whether the application properly fell under Article 177(4). By a majority, the Court of Appeal held that it did. Although the Court of Appeal granted a stay of its judgment for 3 days, the CEO, on the day following the delivery of the judgment, submitted his report to GCOM in response to the 16th June directive of the chairperson. In this report, which he based on the Court of Appeal's decision, the CEO invalidated votes he determined were invalid. This amounted to the exclusion of over 100,000 ballots previously counted and certified as valid during the recount exercise. On 23rd June 2020, Messrs. Ali and Jagdeo applied to this court for special leave to appeal the Court of Appeal's decision. This court invited the parties to make written and oral submissions on the following broad issues. 1. Whether the Court of Appeal had jurisdiction to entertain Ms. David's application. 2. If the Court of Appeal lacked jurisdiction, what is the consequence in relation to this proposed appeal? 3. If the Court of Appeal rightly assumed jurisdiction, what is the consequence in relation to this proposed appeal? And 4. If the Court of Appeal rightly assumed jurisdiction but exceeded their jurisdiction, what is the consequence in relation to this proposed appeal? The court first recognized that Article 123, Subarticle 4 of the Constitution gives Parliament the power to make the CCJ the final Court of Appeal for Guyana. Under this authority, the Caribbean Court of Justice Act, Chapter 307 of the Laws of Guyana was enacted, and this court was indeed made the final Court of Appeal for Guyana. That CCJ Act has all the force of Guyana's domestic law, and it is that act that must guide the question of the CCJ's jurisdiction. Citing the Barbadian case of Barbados Rediffusion Service Limited against Merchandani, the court determined that under the CCJ Act, this court has jurisdiction to entertain applications for special leave to appeal from any decision of the Court of Appeal in any civil matter. This power, however, has to be placed alongside Section 4, subsection 3 of the Act, which provides that the court has no jurisdiction to hear matters from the Court of Appeal which were declared to be final by any law. The court confirmed that Article 177(4) is such a law. The court defined Article 177.4 as a limited and circumscribed carve-out of its broad jurisdiction to grant special leave applications and to determine appeals from the Court of Appeal. The court noted that Article 177.4 is also a carve-out of the exclusive jurisdiction over the validity of elections granted to the High Court by Article 163. The court held that Article 177.4 should be strictly and narrowly construed. There was no doubt that in instances where the Court of Appeal hears a question concerning the validity of an election of a president, where the question depends on that person's qualifications or the interpretation of the Constitution, that decision would be final and unappealable to the CCJ. If no such question arose, however, or if the validity of the election did not depend on a question of the qualification of the person or on the interpretation of the Constitution, then the Court of Appeal would not have jurisdiction under Article 177.4. In such cases, any questions about the validity of any elections must be referred to the High Court under Article 163. And once proceedings to determine those questions commenced in the High Court, there was an appeal right up to this court, if necessary, as the final Court of Appeal. Counsel for Ms. David cited to us a number of authorities to suggest that this court lacked jurisdiction to even entertain the application for special leave to appeal by Mrs. Ali and Jagdeo. The court did not, however, consider these authorities to be helpful. These were all cases where, in the face of a finality clause, the Privy Council declined jurisdiction to hear an appeal from a lower court. Unlike the case here, however, in none of these cases was there any suggestion that the lower court had acted without jurisdiction. This court recognizes and reaffirms its duty as Guyana's final Court of Appeal to ensure adherence to the Constitution. In all the circumstances, and given the constitutional implications and the public importance of this case, the court granted special leave to Mrs. Ali and Jagdeo to argue the merits of their appeal. In addressing the merits of the appeal, the court looked at Guyana's electoral system generally, and also in particular at Article 177 of the Constitution. The court stated that Order 60 did not and could not affect the exclusive jurisdiction of the High Court under Article 163 to determine, among other matters, any question in relation to whether an election has been lawfully conducted. Similarly unaffected was the National Assembly Validity of Elections Act, the Validity Act, which provides the method of questioning the validity of an election through the filing of an election petition. The Validity Act sets out that such a petition must be presented within 28 days of the publishing of the election results, and that the High Court had the power even to order a fresh election in whole or in part. Article 163 provides a constitutionally mandated and evidence-based open justice process under the exclusive jurisdiction of the High Court, with a right of appeal, as indicated, if necessary, to the Court of Appeal and ultimately to this court. The irregularities complained of by Mr. Harmon and alluded to by the CEO were required to be addressed under the jurisdiction conferred by Article 163 by an election petition filed in the High Court. The court held that the GCOM chairperson was right to state that GCOM lacked the legislative authority and the machinery to embark upon a determination of such irregularities. The court then turned to Article 177, which addressed the election of the president. Article 177(2)(b states that a person is deemed to be elected as president when, quote, more votes are cast in favor of the list in which that person is designated as presidential candidate than in favor of any other list, unquote. The president is deemed to have been elected because in Guyana's electoral system, an elector's single ballot is rarely cast in favor of a list of candidates. There is now no separate election of a president, as there used to be in earlier times when the president was elected by the votes of the members of the National Assembly who had already been elected to that body. Article 177(4) was always intended to operate after the president had been elected. This was the case when, originally, the president was elected by members of the National Assembly, and it is so today when the president is deemed and declared to be president after it is determined that more votes were cast in favor of the list in which she or he was designated as a presidential candidate than in favor of any other list. Questions as to the validity of the president's election under Article 177 were never intended to impugn or relate to the validity of ballots cast by electors at the election of members of the National Assembly. Article 177(4) only affords jurisdiction to the Court of Appeal if the question raised as to the validity of an election of a president depends upon the qualification of any person for election or on the interpretation of the Constitution. It is evident from the nature of Ms. David's complaints and the issues she placed before the Court of Appeal that the questions raised by her did not depend on the qualification of any person for election or on the interpretation of the Constitution. Ms. Davis' complaint was really about the impact of Order 60 and about the conduct of GCOM. What the Court of Appeal majority did was to embark upon an exercise of interpreting Order 60. The Court of Appeal majority considered the effect of Order 60 on the responsibilities of GCOM and then applied that to the clear words of Article 177(2)(b). Article 177(2)(b), in fact, required no refinement. That article, in plain and simple language, has always said what it meant and meant what it said. There was no need for an interpretation of that article or any other article of the Constitution. Accordingly, there was nothing in Ms. David's application to trigger the Court of Appeal's jurisdiction under Article 177(4). The Court of Appeal lacked jurisdiction to make the orders that were made. Those orders were not made under Article 177(4) of the Constitution. Counsel for Ms. David also suggested that because the Court of Appeal had interpreted the words of Article 177(2)(b), quote, more votes cast, unquote, and concluded that those words really meant, quote, more valid votes are cast, that their decision then fell within the purview of Article 177(4). The court did not accept that argument. The concept of, quote, valid votes, unquote, is well known to the legislative framework governing the electoral process. The concept has a particular meaning in that context. The phrase appears several times in the Representation of the People Act, including in Section 96 of that Act. That section, Section 96, calls on the Chief Election Officer to calculate the total number of valid votes of electors which have been cast for each list of candidates. Validity in this context means, and could only mean, those votes that on their face are valid. the determination of such validity is a transparent exercise that weeds out of the process, for example, spoilt or rejected ballots. This is an exercise conducted in the presence of the duly appointed candidates and counting agents of contesting parties. It is after such invalid votes are weeded out that the remaining valid votes count towards the determination of not only the members of the National Assembly, but incidentally as well, the various listed presidential candidates. If the integrity of a ballot or the manner in which a vote was procured is questioned beyond this transparent validation exercise, say because of some fundamental irregularity, such as those alleged by Mr. Hammond, then that would be a matter that must be pursued through Article 163 after the elections have been concluded and the victors declared. At the point in the electoral process where Article 177(2)(b) is reached, there is no further need to reference valid votes because, subject to Article 163, which is triggered by election petition after the election, the relevant validation process has already been completed. By the unnecessary insertion into Article 177(2)(b) of the word valid, the Court of Appeal impliedly invited the CEO to engage unilaterally in a further and unlawful validation exercise that trespassed on the exclusive jurisdiction of the High Court established by Article 163. It was inconsistent with the constitutional framework for the CEO or GCOM to disenfranchise tens of thousands of electors in a seemingly non-transparent and arbitrary manner without the due processes established in Article 163 and the Validation Act. For all these reasons, the court adjudged that the provisions of Article 177(4) were not triggered by Ms. David's application to the Court of Appeal. Since the Court of Appeal had no jurisdiction to hear the application brought by her, the finality clause in Article 177(2)(b), in 177(4), was inoperable, and under the laws of Guyana, this court had jurisdiction to hear and determine the application by Messrs. Ali and Jagdeo and to set aside the decision of the Court of Appeal. This court was also entitled and required to declare invalid the report issued by the CEO, which was based on the decision of the Court of Appeal. It follows that the appeal of Messrs. Ali and Jagdeo succeeds. The court was addressed with great passion by some counsel appearing before us to make a raft of consequential orders relating to the elections. In this regard, it is important to bear in mind that this case is essentially about jurisdiction, about our jurisdiction, about the jurisdiction of the Court of Appeal, and even implications for the High Court's exclusive jurisdiction under Article 163 and other articles of the Constitution. The court reminded itself that its jurisdiction had been invoked for the sole purpose of determining whether the Court of Appeal lacked jurisdiction to entertain Ms. David's application and to make the orders that it made. Once we decided that the Court of Appeal's order was made without jurisdiction and should therefore be set aside, there was nothing left upon which this court would possess jurisdiction to make any further consequential orders. To accept counsel's suggestion and proceed down that path would have been to engage in an exercise not dissimilar from the one embraced by the Court of Appeal majority and which we have issued. It is for GCOM to ensure that the CEO submits a report in accordance with its directive of 16 June in order to proceed along the path directed by the laws of Guyana. As Guyana's final court, the court stated that it could not, however, in all the circumstances, pretend to be oblivious to events that have transpired in that country since December 2018. Indeed, the court had to pronounce on some of those events. It has been 4 months since the elections were held, and the country has been without a parliament for well over 1 year. No one in Guyana would consider this to be a satisfactory state of affairs. We express the fervent hope that there would quickly be a peaceable restoration of normalcy. Now, the law must run its course. The judgment of the court was a unanimous one, to which all members of the bench contributed. Ultimately, the court ordered that A, special leave is granted to the applicants to appeal the decision of the Court of Appeal dated 22nd of June 2020. B, the appeal of the appellants is allowed. And C, the said decision of the Court of Appeal was made without jurisdiction. It is invalid. It is of no effect. The court also declared that the report of the Chief Election Officer of 23rd June 2020 is similarly of no effect. The court did not address the issue of costs and is prepared to hear counsel on that issue by written submissions. We don't expect those submissions to exceed, what, 7 pages? 5 pages. And we would expect to receive those submissions within 2 weeks of today's date. Yes, there was another matter filed by Messrs. Ali, Shazam Ali and Abidin Ali. Mr. Khan, are you withdrawing that matter?
Your Honor, if I may, in light of the court's orders, can I ask that, having regard to the order made in the case management, that the matter abide, that the court, for completeness, simply grants an order in identical terms in relation to that application?
No, you can't do it that way. We will, you would either withdraw that matter or we will dismiss it. Which one you prefer us to do?
That being the choice, Your Honor, the application is leave to withdraw.
We note that that application has been withdrawn. Yes. I wish to thank all the attorneys for the assistance which you provided to us. We were very grateful for that assistance, and you would see in the judgment where we have addressed some of the specific submissions which have been made, although where we did not address any submissions that were made, it must not be taken to mean that we did not consider those submissions.
All right.